Yes, good morning to all. Today we will discuss one case law from Trademarks Act. This is the case relating to an infringement or passing off of the trademark by one company which is situated in Delhi. They used the name Prestige for their gas stove products. The company's name is KK Company, K&K Company. They used the name Prestige for their gas stove product. Seeing this, the company which is a TTK Prestige, you all know that Prestige pressure cookers, Prestige pressure fan, all kitchen appliances. That company has filed a case before the High Court. And they have said that they are using this trademark since 1949 and again it was used since 1955. It is continuously they are using these trademarks. But the respondent or the defendant in this case is using it in 1981 and started using the name of Prestige products, that is Prestige gas stove. So people who are seeing this product with the name Prestige will have in their mind that it is associated with the company called as TTK Prestige. So they filed a case before the Honorable High Court for getting a permanent injunction against the defendant, that is K&K Company, KK and Co. Let us see what the case is. Firstly, the order is passed by the High Court, restrained the Delhi-based company from selling gas stoves, kitchenware under Prestige mark. So, in a trademark suit filed by TTK Prestige Limited, Delhi High Court has restrained the KK and Company, Delhi Private Limited, from using the mark Prestige in relation to gas stove or any kitchenware or cookware. Noting that Prestige has been selling its product under the trademark since 1955 and the earliest registration of its mark dates back to 14th December 1949. So earlier you have to see that what is Trademark Act is. A Trademark Act 1999, prior to that is called as Trademark and Merchandise Act 1930. So in the 1949 itself, they obtained the trademark registration under the old act. So the court dismissed the contention that the pressure cooker and gas stoves are different products and therefore there would be no confusion in the market. So what the defendant has said is, see, their product is different. They are only selling the Prestige pressure cookers. That is, TTK Prestige is selling only the pressure cookers. We are selling the Prestige gas stoves. So these two are different. There will not be any confusion in the market. Then they have said that the use of trademark Prestige by the defendant number 1 in respect of gas stove is likely to cause confusion in the market as the public at large would associate the said products of the defendant number 1 with the plaintiff, said the court. So the Prestige has filed a trademark suit before the High Court seeking a degree of permanent injunction against KK and Company, Delhi, alleging that a defendant is selling gas stoves under the impugned mark. In the application seeking interim injunction, the Prestige pleaded that in view of the tremendous goodwill and reputation attained by the usage of the trademark in the respect of pressure cookers, a case of passing off is made out against the defendant. Okay. So it further submitted that a trademark was registered in favor in 1981 in respect of installation for cooking on proposed to be used basis. Just come down. Subsequently, the trademark was registered in its favor, specifically in respect of gas stoves on a proposed to be used basis in September 1999. This is the trademark company, that is KK and Company's argument. The K&K Company in response argued that in case it has been continuously using the trademark since 1981 and thus it is a prior use of trademark in respect of gas stoves. However, the court noted that defendant in support of its contention has placed only 3 invoices on record, that too of the year 1982. So what the court is asking is, if you are using it in a continuous basis, provide the invoices from the years when you are selling this product. We want to know whether you are doing this in a continuously for the long time. That's why they demanded the invoice copies. Even if I go to trademark cases, I used to submit the invoice copies along with the product name, which contains the product name or brand name of the company, to prove that we are using this trademark for a long time. We are having a prior use. That is, we are having an advantage over the defendant, or we are having the using this trademark, so the objection made by the trademark registry is not sustainable. So we used to provide the earlier invoice. In the same way, the court has now asked, give your invoice copies. Where is your invoice copies? So the defendant able to provide only 3 invoice copies, which is in the year 1982 only. After that, they are not unable to provide the invoice copies also. Just come down. As the defendant, 1 minute, just go last paragraph. Yes. However, as the defendant number 1 claims to be continuous user of trademark Prestige from 1981, it should have filed the documents evidencing such continuous user. In the absence of any documents, the court shall presume that there was no continuous user by the defendant number 1. The court said. The bench said that other than the 3 invoices of the year 1982 and few statutory registration in its favor, no credible evidence in the form of invoice or advertisements or other material has been filed to show that defendant has been continuously using the trademark so as to constitute any goodwill or reputation in its favor. Accordingly, I am of the view, that is the judge is on the view, that the defendant number 1 has at best shown sporadic use of the impugned trademark, which would not qualify it as a continuous user in the terms of section 34 of the Act. The bench noted that the Prestige, on the other hand, has placed on record various invoices from the year 2007 to show sales of gas stoves, an advertisement of the year 2019 to show that it is in the business of selling gas stove under the Prestige, under the trademark Prestige. On the basis of the sales turnover as well as the promotional expenses placed on record by the plaintiff has also established at prima facie stage immense goodwill and reputation of its trademark Prestige, albeit in respect of pressure cookers, the court added. The bench further noted that the date of registration in favor of Prestige in respect of installation for cooking is of 16th June 1981. And the 3 invoices filed on behalf of the defendant are admittedly of subsequent date. By holding that the price installation for cooking would cover with the scope gas stoves, the court said that the defendant failed to establish use of trademark prior to the registration granted in favor of Prestige. So, that the defendant not unable to prove that he has obtained the trademark registration prior to the TTK Prestige company's trademark Prestige. Rejecting the arguments that pressure cooker and gas stove are different products. So, the court has rejected the argument that pressure cooker and gas stove are different products. The court observed that since 2 goods are used as a kitchen appliances, so both things, that is pressure cooker and gas stoves, both comes under the kitchen appliances. The use of trademark Prestige by the defendant in respect of gas stoves is likely to cause confusion in the market, as the public at large would associate the product with the Prestige pressure cookers, that is TTK Prestige companies. In view of the above discussion, above prima facie case of infringement as well as passing off is made out on behalf of the plaintiff. Balance of convenience also in favor of plaintiff and against the defendant number 1. The plaintiff shall continue to suffer irreparable injury to its goodwill and reputation if the defendant number 1 is permitted to manufacture and sell goods bearing the impugned trademark. The court thus passed an interim injunction restraining the defendant from using the mark. So after this, I think the case will be gone in favor of TTK Prestige only. The permanent injunction, that is using this word Prestige, is not allowed to the defendant anymore. So this is the case for today. If you are having any doubt, you can ask to me.
No, sir.
No, sir.
Okay.
No, sir.
Okay. Thank you, Ankita. Thanks to all.
Thank you, sir. Thank you, everyone.
Thank you, sir.
Thank you, sir.
Thank you, ma'am.
Thank you, sir.